So, ma'am, many critics argue that the laws like UAPA create a parallel justice system, like you mentioned, denying certain basic rights such as bail and fair trial. So, do you agree to this sentiment? And how can we reconcile national security concerns with the need to prevent the misuse of these laws?
Yeah, well, obviously, as I said, it's a different bail regime, right? Whereas, I mean, just yesterday, I think I was reading somewhere that in a PMLA case, the judge said, bail is an exception in these special laws, right? So otherwise, the general rule is that, jail should be an exception, bail should be the norm, right? But they just overturn it.
Yes.
Bail very difficult to secure. And as I said, preventive detention. For a long time, people are in jail as a kind of preventive detention, right? So, uh, so yeah, of course, it's creating a kind of a parallel system. But the point is that, when you talk about national security, I don't think there is any study anywhere in the world which says that harsher laws or harder laws make for more secure, nations. So, uh, in fact, whenever there is an attack, for example, right, in 2008, the Bombay attack led to further amendments in UAPA, right? The definitions were expanded, new sort of categories of crimes were added, more evidentiary shortcuts were made, the period of um, filing of charge sheets was increased and so on. So these events act as moral panics or moments of moral panic, which allow laws to be even further hardened, right? But that doesn't necessarily mean that they're leading to a more secure, nation state. In fact, if you continually, render some communities suspect, then it's not going to lead to a more secure state at all, right? So you need to. There is, in fact, in the case of Media One, where the Media One channel was shut down, the Chief Justice said that national security is always, it doesn't become a pretext for automatically then having a trial which is not fair. So the recourse to sealed envelopes, withholding information from the accused, uh, on the grounds of national security cannot be justified. I mean, it has to be justified in the sense that you have to have a test of proportionality and so on, right? So I think the use of these constant, the use of these laws. In fact, if you look at a lot of documentation around that, if you look at POTA, and even there is a lot of documentation that we've done on UAPA, which shows that cases are not necessarily filed in response to some national security concern, right? That there is, in fact, it looks as though there is a need to keep the pot boiling, right? And so therefore, many of these cases have been filed, and they've fallen flat in courts later on. So I think national security cannot be addressed through these harsh laws by circumventing, civil liberties. Yeah.
Thank you, ma'am. Ma'am, so what are the real life consequences for individuals and families as a result of this criminalization under the laws such as UAPA?
Um, because bail is so difficult to secure, the consequence of that is that you spend many years in jail, right? And also with this particular kind of law, with if your charges are under UAPA, one finds that there is also a great deal of stigmatization around it, right? So, and also the fear, fear of family members, fear of friends, fear of relatives who would like to shun you, who would rather not have anything to do with you, right? So it leads to certain kind of social isolation. It leads to breakdown in terms of economic, actual livelihood, breakdowns. So it's manifold, and in fact, livelihood, etc., is one part of it, but there is also a great deal of emotional and mental trauma that accompanies, not just for the accused but for their families at large, right? So I think we've not even started looking at the question of reparations, and now, of course, we are in a different phase altogether. But at one point, there was some talk about how there needs to be some reparation for those who've spent many years in jail, right? There have been many cases, for example, in the Akshardham case, where people spent time on death row, in fact, and then they were finally acquitted by the Supreme Court. And the Supreme Court called out not just, it wasn't just the shoddy investigation, but clearly the malicious investigation that, Gujarat police had undertaken. So I think there are many-fold and multifold sort of consequences, both for the individuals and for the families in terms of emotional, mental health, real livelihood issues, social issues, stigmatization, isolation, all of those, impact those accused. Yeah.
Thank you, ma'am. So you've spoken about the laws, old as well as the new ones, and the role of investigation agencies such as the police at the same time. What is the role of the judiciary in this process? And do they step in to restore the rule of law, or do we see them bending to the same prejudice and bias?
See, we've just um, quite recently we had a sitting High Court judge of the Allahabad High Court who made that what is now being called a hate speech, right? He talked about the UCC, the Uniform Civil Code, and he talked about how our Gita and their Quran and so on and so forth, right? And there is apparently an impeachment motion against him. So, uh, and the number of retired and former justices queuing up to speak at various right-wing events kind of gives you an indication as to what has been happening, right? But I think apart from these individuals, I think there are 3 or 4 things that we ought to look at. Firstly, the judiciary's social base is very narrow. Yeah, it's upper caste, male dominated, largely, right? The marginalized sections are very, very poorly represented or not represented at all. So that will have a bearing on the way in which justice is delivered, right? So that is one thing. And secondly, when we look at the whole question of judicial bias or judicial behavior, we tend to look at the pronouncements of the Supreme Court mostly, right? But not really pay attention to what is happening at the lower judiciary, lower courts, right? How they are producing, legal doctrine. So I think that is important. We ought to look at, what's happening there really, right? And what we find is, in fact, there was a retired judge of the Allahabad High Court who said that, he found that lower judiciary was prone to act safely within courts, as they didn't want to, annoy anybody. They didn't want to upset any dominant norms. So they felt that it's safer to just, denying bail to people, right? So it was the safest course. People can go to high courts and people go to Supreme Court, right? So that's the kind of thing that we do. People tend to act safely, as it were, right? And it could be out of ideological commitment, as we've seen many of these other judges, or it could be out of self-preservation. It could be out of desire to get promoted, various things. So and thirdly, I think when we're looking at judicial bias, we ought to look at other kinds of conceptual frameworks in understanding what's happening here, including judicial deference, judicial abdication, right? The deference to the executive, which comes in quite clearly in not just in terror cases, but in a whole range of cases. Or judicial abdication, just not listening to cases, just keeping them in abeyance for a long time. For example, that's what happened in demonetization, right? And then after months and years have passed, you say, oh, it's only an academic matter now. It doesn't have any real consequences, right? Or abrogation of 370, for example, right? So this desire to, I don't know whether to call it pleasing the executive, but certainly of accepting the logic of the executive, and abdicating the judicial logic of, being loyal to the constitutional values. That is also something that we ought to look at. So I think these are the 3 things that very broadly one can, in trying to understand the judiciary. But having said that, I think there are many cases of acquittals which have happened, right? Both at the lower judiciary and at the lower and at the higher court. But I think when it comes to giving bail to people, the judiciary is still very, very, hands-off sort of approach that, let others decide. We don't want to decide. And especially when it comes to terror cases, that, let it be, let the trial commence. Let's not, interfere.
Yes, ma'am. So, ma'am, as we are talking about addressing the judicial bias, right? How do we differentiate it from political or media-driven manipulation of the judicial system, and what challenges arise in making this distinction?
See, I think coming back to the earlier question only, when we look at a case like, when we look at cases filed under UAPA, for example, right? Now, there, the statute itself is limiting, right? The letter of the law is limiting in the sense that it says, no bail to be granted until, the public prosecutor has been heard and prima facie true and so on and so forth, right? Now, there are judges who will go beyond the letter of the law, right? And they will look at the larger constitutional framework,
Hmm.
and the larger constitutional values and the kind of fundamental rights that are enshrined there, right? And therefore, sort of look at the statute, such as the UAP and the various sections in it, in that framework, right? So you have had judges like Justice Muralidhar and Justice Sipse, etc., who've done this kind of exercise, right? Who've done an interpretive exercise of this kind, and have looked at, say, Section 20 of UAP and said, how does it counterbalance with Article 19 of the Constitution, which says, right to freedom of speech and expression and so on, right? So that is one thing. But those who limit themselves, and that's the question of how do you look at judicial bias operating? I think what we see is their, I wouldn't say an inability, but their desire not to go beyond the limits of the statute, right? To argue, to cloak that within the aura of technicality, right? So you look at the technicalities of the law and say, oh, it's not possible, right? It's not possible, right? So to cloak that in the aura of technicality, that's what we've seen. So you will not, so that's also an interpretive exercise, but you will say that, oh, I'm not, so this, there's a law, there's a legal scholar called Dijsselhoos who looked at the um, cases in the South African apartheid courts, right? And he talked about how the judges were. So he says, I'm not saying that the judges are all racist, right? But the judges are using an argument of constitutional positivism, saying that we are bound by the letter of the law, and so therefore we cannot go beyond that, right? And so this is what we see happening here as well. It's an interpretive exercise, but at the same time, which says that I'm not interpreting, right? I'm not reaching out, or I'm not framing my argument in terms of the larger constitutional values. I'm very narrowly sticking to what's the letter of the law in front of me. And this is what happened, for example, in the famous Vatali case. Now in the Zahur Vatali case, the High Court, the Delhi High Court said that, because it's a case of this nature, it's a case of financial terrorism, because it's a case of this nature, and because the penalties are so high and the charges are so grave, we will take an exercise. We will undertake an exercise of scrutiny, which will scrutinize the material to a great degree, right? And so it said that the material provided by the investigating agency, the NIA, wasn't enough. He says, I don't want to be a post office for the NIA, right? I'm not a mere rubber stamp for the NIA. I will scrutinize, right? But when it went to the Supreme Court, when the NIA appealed against that case in Supreme Court, the Supreme Court said, oh, no, you cannot do that. You only look at, you're not conducting a mini trial. You only need to look at the material in front of you, right? So I think what happens is that when you're looking at the way in which the judiciary behaves, I think what they do is they cloak their arguments in these sort of technical, language and arguments, and limit themselves to the statute of the law without reference to the larger constitutional values, which should have informed, the workings of the court.
Thank you, ma'am, so much. Now, our final question during this podcast is that what could be the way ahead, and how can the other stakeholders, such as let us take media or civil society organizations or research institutions, address this issue at a larger scale?
Well, it's always a question that foxes me. I don't know, really, because I think firstly is to speak out. I think that's the most important thing. And as students, as researchers, as teachers, as civil society activists, all we can do is that not accept the kind of stuff that's being thrown to us, really. No? And it's not just UAPA, but you look at the whole sort of legal architecture that's being built around us now. It is, the love jihad laws, the conversion laws, the cow slaughter law, all of these, which are actually hollowing out democracy, right? So as anybody who's interested in fertilizing and in deepening democracy, I think it's important for all of us to speak out and to resist this. I think that's all I can say. I have no sort of policy framework to give to you at this moment.
Thank you so much, ma'am, for joining us for the podcast and contributing to this important discourse. And yeah, we'd love to host you here once again in Hyderabad soon.